Hello, everyone. We've been talking this week about immigration bans and how being in the United States illegally may impact your desire to immigrate to the United States. We talked about the unlawful presence waiver, 601A, and today we are going to talk about some other waivers available to immigrants who may have something that will make it so that they are inadmissible to U.S. A waiver is something that, if granted, can be used by the determining officer to approve your application to immigrate to the United States and become a citizen, even if you have something in your background that could be grounds for denial. I am Raluca Hanea. I provide immigration, estate planning, and family law services for my clients. And Nina Clear, my marketing and office manager, is here with me. All of your likes, shares, and comments help others to see our videos, so we are really grateful for all of them.
And I know it's kind of broad. We're like something, 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 but it's because there's a lot of somethings, right? Yes. So just to review it again, because this is very complicated, will you tell us what a waiver is?
Sure. There are certain things that may keep you from being in the U.S. and would be an automatic grounds for denial, such as having been in the U.S. without a legal status, a criminal history or health issues, and people can apply for a waiver, which, if granted, is used when an officer is determining if a person can get a visa or green card. So it basically waives the issues that would be an automatic denial and can allow the officer to approve their application.
And I know you mentioned this already, but we talked about the 601A waiver, and just remind everybody what that one is for.
Yes, that one is a very narrow, specific waiver and covers only unlawful presence in the United States.
And what is unlawful presence?
When you are over 18 and have been in United States for over 180 days without a legal status, you are said to have been here unlawfully.
And why is that important?
It's important because having an unlawful presence in the United States over 180 days can ban you to come here for 3 or 10 years, as well as be grounds for denial for certain visa or immigrant applications.
And an example of that might be a person who entered the United States on a tourist visa, and when they came in, they got an I-94. It was a stamp. Now it's something on the computer, but it says you can stay here for this allotted time, yes. And they have stayed past that allotted time, right?
That's right. And people often get confused with this because the visa might be good for 10 years, your tourist visa, but the customs agent only allows you to be in the United States for a certain period of time, usually 6 months. And if you stay past that time, you are typically here unlawfully unless you have applied for and been granted an extension or a change of status.
Okay, and that isn't the only reason you can be denied, right?
No, there are more reasons.
Okay, will you tell us about them?
Sure, and this is just a short list, but there are many more. So it includes things like your health, immunization background and mental state, your criminal background, prior removals from United States, fraud or misrepresentation, the possibility that you may become a public charge, and national security reasons, as well as a variety of miscellaneous grounds.
So you have one of those issues. Can you apply for a waiver from them?
It really depends on your individual circumstances, and I recommend talking to a qualified immigration attorney so that they can review with you if a waiver is likely to be granted for you.
And have you helped clients obtain one of these waivers?
I have.
So I know we talked about the unlawful presence waiver and how there was a fee, and it's a different application than this one for that. So is there a fee with the 601 waiver?
Yes, as of today, May 10, 2019, the government filing fee is $930.
And some people might have to file both a 601A and 601 waiver, or a 601 waiver and a different one, and pay both the fees, right?
Yes. They, again, they may depend, they may pay this, but it depends a lot on the individual circumstances. I can't talk anymore. This is why it's really important to talk to an attorney. They will be able to give you the best advice, based on the facts of your case. So if you know someone who applied for it,
Don't take their advice.
It doesn't mean that it applies in your case.
Okay. And I know for the 601A, only people who met certain conditions could apply for it. Is that true for the 601 as well?
It is. One of the big things with this waiver is that for most applicants, you must have attended a consulate interview and the officer determined that you were inadmissible to the United States for one of the grounds covered by the waiver. And after you were denied admission to the United States, then you or the attorney that you hire files the application for this waiver.
And does the consular officer tell you if you can file for a waiver?
They do.
What if you have more than one reason for being inadmissible? Do you need to file 2 applications?
No, you should file one, but you need to list all of the reasons that might make you inadmissible.
But again, sometimes based on your circumstances, there's other applications you have to file with this one.
That's true.
So that's why we say talk to an attorney and tell them your individual circumstances, because this is very broad information.
Yes,
Okay.
and this area waivers, it's very complex. So
Okay. And then do you need to prove for the 601, I know in the 601A video, you talked that you have to prove there's an extreme hardship for one of your qualifying relatives. Is that
That's right.
true with the 601?
yes, it's true for this one as well.
Okay. And do you know how long it is taking to process the 601 applications?
Right now, it looks like it is taking about 14 months. They are working on applications submitted in March 2018. But that does not include any applications that were sent an RFE, request for evidence, or an NOID that we talked before, notice of intent to deny. So it may be longer than 14 months. So thank you for watching, and thank you for all your comments and likes. We're always here to help, and have a great weekend. See you soon.